Imagine this situation for a moment. Someone is secretly drugged or forced to consume alcohol, loses control over their senses, and then ends up doing something they would never do in a normal state of mind. Should that person be treated like a criminal? This is exactly where Section 23 of the Bharatiya Nyaya Sanhita 2023 comes into play. Welcome to Quick Law Insight, where we explain the law in the simplest way possible. Section 23 says that a person will not be considered guilty of an offense if they were so intoxicated that they could not understand what they were doing, provided that the intoxication was not voluntary. In simple words, if someone was intoxicated without their knowledge or against their will, the law gives them protection. This section focuses on the state of mind of the person at the time of the act. The law understands that criminal responsibility depends on awareness and intention. If a person is unable to judge whether an act is right or wrong, or even understand the nature of the act itself, then blaming them would be unfair. However, this protection is not available if the person willingly consumed alcohol or drugs. If someone chooses to get drunk or take substances on their own and then commits an offense, they cannot use Section 23 as a defense. The law clearly separates involuntary intoxication from self-induced intoxication. So, the key idea is simple. If a person is drugged, forced to drink, or intoxicated without consent, and because of that they lose the ability to understand their actions, then the law does not treat their act as a crime. In short, Section 23 protects innocent and vulnerable individuals from criminal liability when their judgment is taken away without their choice. It reminds us that punishment should be based on intention, awareness, and fairness. That's all for today on Quick Law Insight. If you want more easy explanations of complex laws, stay connected and keep learning.